No, that's not true. It's cause or attempt to cause.
I'm not talking about the second section, sir. We'll get to that in a moment.
That's in the same definition.
It's not. Would you disagree with me if I told you it was not?
I could read from my report.
And one moment, Your Honor.
You may.
Yeah, I have the yellow. I'm referring to page 13 of your report, sir, just so we're on the same page here. See that?
Yes, two sections, correct.
And I'm looking at the bottom of page 13 where it says Ohio Revised Code, section 2903.11, felonious assault. And there are two sections or two ways to commit the crime of felonious assault. Is that right?
As I agreed to, yes.
Number one, under A1, is no person shall knowingly do either of the following. First, you can commit felonious assault by causing serious physical harm to another or another's unborn.
That's part of the definition, correct?
Well, that's the only definition to A1, correct?
But A2 is attempt to cause physical harm,
That's a separate crime.
but a crime of felonious assault.
Okay, well, I want to talk about A1.
Oh,
Let's not get confusing, okay? We're going to talk about A1 and then we'll talk about A2,
okay.
okay? A1, the crime of felonious assault, cause serious physical harm to another person. Causing serious physical harm is an essential element of that crime, is it not?
Of A1, yes.
And without actual serious physical harm being caused, there is no violation of A1. Would you agree with that?
No, not of A1, correct.
And you would agree in this particular case that the defendant, Officer Grubb, did not suffer serious physical harm, correct?
That is correct.
So we don't have any violation of A1. Would you be in agreement with that?
That is correct.
Now let's talk about A2. Felonious assault under A2 talks about causing or attempting to cause physical harm to another by means of a deadly weapon. Would you agree with that?
That's correct.
And under this particular section, or this method of committing felonious assault, the person would have to knowingly attempt to cause physical harm by means of a deadly weapon. Would you agree with that?
Yes.
I want to, if we can, may we move to the computer? It's going to be State's Exhibit 3. It's the defendant's body-worn camera, a portion thereof. You've reviewed the body-worn camera in this case, have you not?
I have, yes.
In fact, you used it as the basis of the case, at least part of the basis.
Part of the basis, yes.
I want to show you a clip of Officer Grubb's body-worn camera. We can play that.
Then get out. No, then get out.
Get out of the fucking car.
Get out of the car.
Get out of the fucking car.
You would agree with me, Mr. Davis. Actually, let's go back, and I want to look at that, and let me ask you to pay close attention to Miss Young and the positioning of her hands, okay, within the vehicle.
Then get out. No, then get out.
Get out of the fucking car.
Get out of the car.
Get out of the fucking car.
You would agree with me, Mr. Davis, would you not, that before the vehicle ever makes contact with the defendant, the body-worn camera clearly shows Miss Young physically turning her steering wheel to the right.
That's correct, as I testified to earlier, yes.
In fact, before Officer Grubb's weapon even comes into view, we can see her turning with her hands the steering wheel all the way to the right.
I don't know if it was all the way to the right, but to the right, yes.
I want to talk about aggravated robbery as well, because you mentioned that as a potential felony that I guess Miss Young was committing, in your opinion. Is that right?
That is correct.
And with it, as it relates to aggravated robbery requires that someone in attempting, committing the theft offense, or fleeing immediately thereafter inflicts or attempts to inflict serious physical harm on another. Would you agree with that?
That is correct.
So if we break this down, I think you would agree, based on your prior answers, that the actual infliction of serious physical harm did not occur in this case.
That is correct.
So we're left with the attempt, correct?
That is correct.
The attempt to inflict serious physical harm on another, in this case the defendant, would have to be shown. Is that right?
Yes.
And it would have to be proven that Ms. Young specifically attempted to inflict serious physical harm on the defendant, Officer Grubb.
By way of her actions, yes.
And you've already agreed that before her car even starts moving, she's turning that steering wheel all the way to the right.
No, I didn't say all the way to the right. I said turn to the right. I don't know to what extent.
Okay. Well, we do know, because we saw the video. It's not just a minor turn, is it?
Well, I don't know how much the wheel turns. I didn't operate the vehicle. I can't testify that it was all the way to the right.
Can you testify that it was hand over hand turning of the steering wheel?
It was certainly turning to the right, correct?
And not only do we see the steering wheel turning, we see the torque of the wheels go to the right in some of even the still images that you shared with us. Is that right?
Yes, the wheels are turned to the right, correct?
I want to talk to you about page 15 of your report, Mr. Davis, and that is a table regarding law enforcement officers being feloniously killed. Okay.
Yes, correct, correct.
Now, we've heard a lot of talk during the course of the trial about what the number one cause of death of police officers here in the United States is. So I want to ask you a little bit about your chart. You talked a little bit about it on direct. First, can you tell us, where is this chart derived from?
This comes from the Federal Bureau of Investigation, something called LEOCA, Law Enforcement Officers Killed and Assaulted Study. It's a study that's done every year by the FBI and published.
Can we have the computer, please? Thank you. Now, it talks about a time frame. It says law enforcement officers feloniously killed, type of weapon, 2014 to 2023. Do you see that?
I do, yes.
That's a 10-year time frame?
Yes.
And then underneath that, it talks about types of weapons, number of victim officers. On the line where we see number of victim officers, we see a total of 549 officers. Is that right?
That's correct, for the 10-year total.
For the 10-year total.
Correct.
That breaks it down by year thereafter.
Correct.
And I'm going to be looking at just the total column
Okay,
right now for my questions, just so you're aware, okay?
all right.
So 549, I'm assuming that relates to the total number of police officers feloniously killed in that 10-year period.
That is correct, yes.
Now, underneath that, we see total firearms. Is that right?
That is correct, yes.
And the number 480.
Yes,
So that 480 is the total number out of that 549 of officers that were unfortunately killed by firearm.
yes, that is the leading cause of death of officers.
And then we can see underneath total firearms, it breaks it down, what I'll call individually, for lack of a better way to explain it, as handgun, rifle, shotgun, etc.
Correct.
And we even have some numbers there toward the bottom under total firearms of types of firearms, not, I guess the type of firearm wasn't reported, whether it was a shotgun versus a handgun, rifle, that type of thing.
Correct.
And that number is 87 for the record.
Yes.
I want to go down a little further, and we can see where it says vehicle. Total officers killed by vehicle is 47, is that right?
In that 10-year period, that is correct.
Now, you would agree 47 is less than 480. I don't mean to sound facetious, but
Well, under the circumstances, one is too many, I think you'll agree, but yes.
absolutely. In fact, 480, the number of times an officer has been killed by a firearm is over 10 times the number of times an officer was killed by a vehicle during this 10-year period. Would you agree with that?
That is correct.
So if witnesses throughout the course of this trial were told that the leading cause of death of officers here in the United States was a motor vehicle, that would not be true, would it?
No, primarily during the 10 years and past years, it's firearms, but primarily handguns, as we can see, are the biggest thing, biggest firearm used against law enforcement officers.
Now, you've testified in other states, is that right?
I have, yes.
You told the ladies and gentlemen that you now make your living, that you're retired as an expert witness consultant, that type of thing.
I wouldn't say I make my living, but I run a business where I consult and offer testimony, yes.
But you're paid for it.
I am. I don't know whether I make a living out of it, but I am paid, yes.
$300 an hour is not bad. Would you agree with that?
It's not like an attorney where you have constant clients, counselor.
You've never worked as a police officer in any state other than Ohio. Is that fair to say?
No, just in Ohio.
Albeit you've not worked outside of Ohio as a law enforcement officer, you've gone to other states other than Ohio to testify as a use of force expert.
Testify and to train officers, yes.
You've testified in a number of police officer shooting cases. I think you've told us that on your direct testimony. Is that right?
I have, yes.
And you've written probably even more reports on cases than you've testified.
Yes.
And in those reports, you state your opinions and the reasoning behind those opinions.
Yes.
Every case is different. Would you agree with that?
Every case is different, yes.
Each case involves different facts, different circumstances.
That's correct. Same legal, but yes.
You issued, I believe, 3 reports in this case. Does that sound right? You have an original report dated July 30th of this year, 2025, which the state received the following day on August 1st. And then there were some, I guess, corrections made to a report.
Typos, yes.
And that was issued sometime around November 11th. Is that fair?
Yes, I believe that's the correct date.
And then there was a third report, what I'll call a third report, with some additional, I guess, corrections made that was issued just over this past weekend.
That's correct, typos. Mhm.
And I want to understand, and do we have a slide? Can we get the computer? As it relates to, and I want to talk about page 66 of your report, if you have it in front of you. If not, I have it up here on the screen.
Okay.
On the left is the November report, the July report, and the November 11th, and the November, those 2 first reports. But I just want to make sure that we're talking about the same typos. On the right-hand side is the one that you just issued this weekend. Would you agree with that?
Correct. That was a correction to typos in the report on the left.
In the names.
Correct.
Okay. So for instance, and I've highlighted these just for the record, for instance, On the left in that paragraph, we have the wrong officer's name, albeit Officer Anderson, and the wrong, I guess, victim or individual that maybe was shot, Lewis,
That's correct.
and then Officer Anderson's name again, and now you've corrected that to be Officer Grubb, and Young, referring to Miss Young, and then Officer Grubb again, is that right?
Yes.
The rest of that wording in that paragraph essentially looks to be exactly the same. Would you agree with that?
Well, it's written for Officer Grubb's case. I can't recall, proof positive that I didn't write my reports, that there is human error and typos, et cetera. So I can't recall what that was about, but I did catch it prior to trial.
Essentially cut and paste error.
No, I don't believe that's accurate. The one on the left is for this case. It was just the wrong names were included.
Well, the one on the left talks about Officer Anderson, but you're saying that was for this case, you just typed in the wrong name?
I can't recall, Counselor.
Are there portions of your report that contain the same language that you've used in other reports?
Primarily, it's citations to the legal standards, but I think that is pretty much industry standard with all experts, yes.
You can take that down. As part of your analysis in this case, Mr. Davis, you indicated that you looked at the Blendon Township police policies. Is that correct?
I did, yes.
May I have the Elmo? I'm going to look at, for the record, page 72 of your report, sir. Referring you specifically to the section that talks about 300.4.1 entitled Moving Vehicles. Do you see that section?
I do, yes.
And that's part of Blendon Township's written policies, is it not?
Yes, they're guidelines for their officers, correct.
Where it says, shots fired at or from a moving vehicle involve additional considerations and risks and are rarely effective. Would you agree with that?
Correct.
And this policy specifically tells an officer that they should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm. Would you agree with that?
When feasible, yes.
When feasible.
Correct.
And it additionally states the officer should only discharge their firearm at a moving vehicle when the officer reasonably believes there are no other reasonable means available to avert the imminent threat of the vehicle. Would you agree with that?
That's correct.
Now, police policies are not case law, correct?
They're not legal standards, correct.
But they are put into place for a purpose.
They are guidelines to inform and guide officers on the street, yes.
They're put in place to protect the officer. Would you agree with that?
Both the officer and the public, yes.
And officers are expected to follow the department's guidelines, are they not?
There's a ton of different guidelines and policies for most agencies, and they usually rank them. Use of force would be at the top in terms of criticality, but other things like where you're supposed to park are not so critical. So there's a ton of different guidelines and policies.
Where you're supposed to park your vehicle is not critical, but when you shoot at someone is pretty critical. Would you agree?
That is correct.
move on to your report, and I think it's somewhere around page 20 of your report, just for your reference. And beginning on page 20 of your report, you make a point of quoting the defendant's written statement that was provided to investigators in this case. And then I believe you go through various video segments or screenshots from videos and attempt, according to what you state in your report, you attempt to quote unquote confirm essentially the words that were used in the defendant's written statement, or did it happen how he said it happened?
To develop totality of the circumstances to make a determination on whether I believe that the use of force was reasonable or not, yes.
And on page 20 to 21 of your report, you actually quote a portion of the defendant's written statement. Would you agree with that?
That is correct.
And you're quoting on those pages of your report a section of the defendant's statement from page 3 of his written statement. Would you agree with that? And I can give you a copy of that if it would help you.
It would help, thank you.
May I approach, Judge?
Ready?
I'm going to show you, Mr. Davis would have been marked previously as State's Exhibit 66.
Okay.
Copy of the defendant's written statement, or typewritten statement, I should say.
Yes.
And I was asking you about the portion that you quoted on page 20 and 21. And I believe that comes from excerpts from page 3 of his statement.
Starting on page 2.
And your quote ends with wording from, what would you say, page 4?
Yes, page 4, correct.
And you words, albeit from page 2 to 4, that the defendant put in his statement, and you went and you reviewed the video, correct?
I reviewed the entirety of his statement as well as reviewing the video, yes.
Well, there were portions of his statement that you didn't put in your pages 20 to 21 or 20.
Well, I'm sure there is, it's a 6-page total statement. I didn't include all of that.
Well, I want to talk about a portion that you didn't provide, okay?
Okay.
At least that you didn't put in your report, all right? And that's going to be a section from page 5.
Go ahead, sir.
Would you agree with me, from what you've looked at, you didn't put any portion quoted in your report from page 5 of the statement?
Not in this section that I can see, no.
I want to retrieve that from you. We have the Elmo, please. And the section I'm referring to, Mr. Davis, is the sentence starting, "At the time I fired my weapon. At the time I fired my weapon, I was in fear for my life."
I'm sorry, let me try to find that. Okay, at the beginning, at the top of the page. Go ahead, sir.
"At the time I fired my weapon, I was in fear for my life, as the suspect had just struck me, with her vehicle. My feet were no longer on the ground, and the top half of my body was on the hood of her car." You see that?
I do, yes.
Now would that be an important statement for you?
Yeah, it coincides with the body-worn camera videos, yes.
With his top half of his body being on the hood of her car?
His feet off the pavement and his torso over the vehicle, yes.
His top half of his body on the hood of her car. Did you see that in your video analysis?
I don't know that I saw that specific thing. I took that to mean that over the vehicle, or over the hood of the vehicle, yes.
You were interpreting the defendant's words for him?
No, that's what I took that to mean. I can only interpret based on my opinion, yes.
Well, why didn't you interpret it to mean exactly what it says, that his top half of his body was on the hood of the car?
It doesn't say lying on top of the hood of the car.
Oh, okay. Now Now, you reviewed a number of items of discovery regarding this case, is that right?
I did, yes.
And obviously, the video was an important part.
Video is plural, yes.
And the defendant's written statement was an important part.
That's correct, yes.
Anytime a defendant, officer in this type of case, gives a description as to what he alleges happened to cause him to discharge his weapon, that's an important statement.
Yes, that's correct.
And it was your intention to compare what he said in his statements to what you saw in the videos.
Yes, to develop totality of the circumstances at the moment that he used force, yes.
Now, I never saw in your report, and your report is 70 plus pages, is that right?
I think it's actually 89 pages. Oh, I'm sorry, more than that, 91.
In those 91 pages, I did not see any reference to a statement that the defendant made to Westerville Fire Department medics. Did you include that in your report?
No,
A statement, just so I'm clear, a statement that the defendant made to Westerville medics, telling the medics what had happened as the car allegedly hit him and caused him to discharge his weapon. You did not put that in your report.
I did not know.
Any particular reason?
Based on his statement and the body-worn cameras, my focus was on the use of force, not articulation afterwards in terms of third parties or what have you.
I don't know what that means. Help me understand what you just said. I thought you were telling us earlier that it would be very important for you to know what statements the defendant made to someone describing the events that caused him to discharge his weapon.
Well, certainly his statement is his version of events that justify his use of force, or as he is attempting to articulate his use of force. That is looked at versus statements to third parties. There was no focus on that in my investigation. I focused on the moment that force was used.
You're aware that the defendant was taken away from the Kroger scene in a sheriff's cruiser, are you not? Seen at Kroger, I should say.
Taken away
After
from
the
the scene,
shooting.
yes, officers usually transported away from the scene,
And
correct?
he was driven back to the Blendon Township Police Department.
Yes,
And once he was back at the police department, there were some Westerville medics that were asked to essentially evaluate him for any potential injuries. You're aware of that?
yes, I'm aware of that.
And you're aware in the course of his contact with those medics that he did make a statement telling them what had occurred.
I remember seeing that in discovery, but it was not the focus of my investigation.
Well, let me ask you, are you aware that he told medic Nick Adkins that when the vehicle struck him, he was thrown off of the hood and onto the ground?
I don't know that that is not in keeping. He was certainly propelled off the vehicle, so I don't know the specifics, in terms of what he felt at the moment that force was used.
Okay, well, let's break it down because that wasn't exactly my question. My question was, were you aware that the defendant made the statement to medic Adkins that he was thrown off of the hood of Miss Young's car and onto the ground? Were you aware that he made that statement?
As part of discovery, I was afforded that statement, yes.
And you chose not to put that in your report?
That's correct.
When you were taking excerpts from the defendant's written statement and quoting them in your report, you remember that?
Yes, his official written statement of what he stated transpired, yes.
Expired with what you saw actually happen on the video, correct?
That's correct.
That's part of your analysis.
That is correct.
What you're getting paid to do.
That is correct.
You're not telling the ladies and gentlemen that Nick Adkins was lying, are you?
I don't know what, if or what Mr. What's his name?
Medic.
The medic, what the medic testified to. I'm not aware of that.
Well, he testified to the statement. You're not saying that that's untrue, that the defendant made that statement to him, are you?
Once again, I'm not aware as to what he testified to.
Nowhere in the video analysis that you performed in this case, Mr. Davis, did you ever see the defendant be thrown off of the hood of the car onto the ground? Would you agree with that?
It depends on what throw means, Counselor. Thrown to the ground, that his torso hit the pavement, that didn't happen. But was he propelled off the front of the vehicle and happen?
Well, we're playing some word games here, I feel like. I'm just gonna go from what he said, that he was thrown off of the hood onto the ground. Did you ever see that happen?
Yes, he landed on the ground, Counselor.
He did.
He landed on the ground, yes.
You're telling the ladies and gentlemen that this defendant was thrown off of the hood and landed on the ground.
Yeah, his feet, it's in the video.
His feet.
Well, I'm sorry, that's landed on the ground. He didn't land on something else. He landed on the asphalt of the parking lot, Counselor.
So you, again, are interpreting the words thrown off of the hood and onto the landed on my feet.
I don't think it was that motion, Counselor, but we can watch the video and see Officer Grubb propelled off the front of the vehicle and recover his footing on the side of the vehicle.
You would agree with me, Mr. Davis, would you not, that if the information the defendant gives as to the events that led him to fire his weapon is determined not to be true, that that could affect the reasonableness of any perceived threat?
I don't see any, he landed on the ground, that's all I can say.
That's not my question. My question to you is if the information that this defendant gives as to the facts that led him, the events that transpired that led him to fire his weapon are not true, that could affect the reasonableness of a perceived threat.
If that's found in the case, yes.
Now, you mentioned a little bit, you talked a little bit about positioning, cover, contact and cover. Remember that?
Yes.
And you talked about the position that the defendant took at the front of the vehicle, correct?
Correct.
And you talked about other areas where he maybe could have stood, but I guess in your opinion wasn't a tactical sound idea.
Well, they're subjective. So he could have stood in other areas, but the question was, you know, when he stood in front of the vehicle, was that tactically sound? And based on the circumstances, yes.
And you mentioned specifically that he could have stood in the back of the vehicle. You remember saying that?
No, I said that, you know, the problem with that is limited visibility in terms of seeing the occupants. Obviously, you're behind the seats, you're behind the driver.
And you talked about the reason he may not be able to see is because of the window tint, remember?
But that's a possibility.
Now, you didn't measure the window tint of this Lexus, did you?
No, I did not.
Have you ever even physically seen the Lexus in person?
No, I have not.
You don't know what, if any, tint may even be present on that back window. Is that fair to say?
No, other than watching the video.
You also said that he could have stood next to Sergeant Moynihan.
I believe the question was that a possibility? And the answer is yes, he could have stood in a variety of different positions around the vehicle.
One of the factors an officer should consider in terms of where they're going to stand is whether they're going to be in crossfire. You mentioned that.
That is correct.
And that not only includes crossfire with another police officer, but that would include crossfire with innocent civilians, would it not?
It's a tough situation in a parking lot, or in the totality of the circumstances as in Kroger, because of you had people pretty much 360 degrees around the vehicle.
Well, you watched the video, am I right?
I did, yes.
And you're aware there were people not on the outskirts of the parking lot, but right next to the vehicle, citizens. Did you see them?
On the passenger side, there was a citizen, and to the rear of the vehicle, we know there were citizens, but they were involved with the lockout. There were also, I believe, other persons to the south or to the front of the vehicle in the parking area.
Now you say, but they were involved in a lockout. They still are subject to being shot, potentially, are they not?
Oh, yes.
You mentioned, Mr. Davis, about body-worn cameras and talking about them not being, I wrote down the quote, they're not real life. Do you remember that?
It's not the real event. It's a two-dimensional image of what the camera captures, correct?
But you used the body-worn cameras in forming your opinions, did you not?
I used all the digital video evidence,
Kroger included.
the surveillance cameras, correct?
May I have a moment, Judge? That's all I have right now. Sir, thank you.
Thank you.
Any redirect?
May I inquire? Thank you. Mr. Davis, I want to start where Mr. Brandt kind of left off. Did you hear him make a comment about wordplay?
Yeah, well, I'll extrapolate, Counselor, ask it about a
Do you
different
remember
question.
when he asked you why you included Connor's statement of being thrown off the hood of the car, or his partial body on the hood of the car, those and how they intermix?
Yes,
Does Connor's words of either being thrown off the car or having his partial body off the car change the fact that he was hit by that car?
no,
Does that change whether or not being hit by a car is an imminent threat?
no,
Was the car an imminent? Why is that, sir?
because of the vehicle had, Ms. Young had accelerated the vehicle into the officer as he was in the front of the vehicle.
Do you remember the questions Mr. Brandt asked you about what it was that Connor told the medic?
I do, yes.
If I told you he told every one of the medics that he got struck by the car, is that consistent with perceiving an imminent threat?
Yes,
When medics ask a person questions, they're asking for treatment purposes. You would agree with that, right?
in my experience, yes.
Your purpose isn't to treat Connor, is it?
No,
Your purpose is to analyze whether or not the use of force was in fact reasonable. Is that correct?
that is correct.
The reason why you included his statement is because you prefer his words over a medic's words, right?
They're a direct version of his events as recorded to investigators, yes.
You would agree with me that the report you reviewed by the medic was written by the medic, right?
Yes,
So anything in that statement is coming from a third party. Would you agree with that?
filtered through a third party, yes.
I want to talk to you about the policies that Mr. Brandt talked to you on direct examination. Do you remember the policy? I think it's on page 72 of your report, 300.41.
Okay,
You're at that policy?
I am, yes.
And it says, the keywords there are when feasible. Would you agree with that?
Yes, Counselor didn't include that in his question, but when feasible, yes.
And what does it say for the ladies and gentlemen of the jury?
When feasible, officers should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm at the vehicle or any of its occupants.
Was it feasible here?
No, because of the circumstances, no.
The circumstances of the 1.665 seconds?
The circumstances that Ms. Young, created by accelerating her vehicle into the officer, yes.
When you accelerate a vehicle into an officer, is that an imminent threat?
It can be, yes.
Should Connor have just let her run him over?
No, he has he has a responsibility to protect his own life.
Thank you, Mr. Davis.
Mr. Brand, any questions as a result of those?
Based on your review of the discovery, Mr. Davis, you're aware that medic Nick Adkins was not at Kroger when this shooting incident occurred, correct?
That is correct.
So any information he documented in his report in terms of statements would have come directly from the defendant, is that right?
If it's an accurate report, yes.
You were asked questions, can I have the Elmo, please? Thank you. You were asked questions about the Glendon Township policy, and the officer should make every effort to move out of the way when feasible.
I think it's the opposite. When feasible, the officer should make every time.
I want to show you one of your still photos here. This is a still photo from your presentation earlier this morning. Would you agree with that?
That was one of the, yes.
There's nothing behind the defendant to preclude him from taking steps backwards. Would you agree with that?
Nothing behind him?
Yes.
No, nothing behind him.
There's nothing precluding him from taking steps to the right. Would you agree with that?
Well, it's very tough to move laterally when force is applied to you, into you. That makes sense. And the vehicle is moving into him. And at that time, it's very hard to move under those circumstances.
One of the things you talked about is the video doesn't show us the perception of what the officer is feeling.
Objection, Your Honor. I didn't ask any questions about that perception of the officer on cross-examination on the body-worn camera.
Counsel, one approach?
Yes, Your Honor.
May I inquire, Your Honor?
You may.
Mr. Davis, you can't personally tell us what sensation Officer Grubb may have been feeling at that moment. Would you agree with that?
No, I cannot. I can only go from his statements.
That's all I have, Judge. Thank you.
All right. Ladies and gentlemen, counsel, one approach? You can step down.
Thank you, Your Honor.
this time, ladies and gentlemen, we're going to break for the day. If you can be back here tomorrow, again, you guys are just unbelievable, showing up on time and in the perfect spot. If you can be back here at 8:45 tomorrow morning, do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. Have a good evening.
All rise.